What up, IGTV and Facebook? It's your boy Brent Sibley, and I am heading to a mediation. If you're following me on Instagram, you already know that. So I wanted to take a second and talk about mediation, what mediation is, and when you have to go to mediation. So mediation is part of the lawsuit process or the litigation process in Florida, and basically what happens is, if you've watched other videos, you know that not every case even has to go to litigation, like the video I made yesterday, but for cases that have to go into litigation because you can't make a settlement, a fair settlement, you go into litigation, you get assigned a judge, and you, in Florida, before you can go to trial, the judge will order you a mandatory referral to mediation. Usually it comes when you ask the court, when you ask the judge, you say, okay, judge, we did all the preliminary stuff in our lawsuit. We're ready to go to trial. We're ready to get the jury to decide the case. And they say, okay, we'll give you a trial date. It's later this year, whatever, 60 days, 90, usually it's 120 days out from the day you ask. But the judge will say, you have to go to mediation first. When you come back later, 30 days before trial, if you haven't gone to mediation, the judge might sanction you and he might kick you off and he might not let you go to trial. So it's mandatory and you have to go to mediation. Now, mediation doesn't mean that you do have to go, and you have to go in good faith, and you have to cooperate, and you have to use your best efforts, okay? Doesn't mean you have to settle your case, obviously. You have to show up and you have to use best efforts to try and settle your case. All the attorneys for all the parties involved in the lawsuit will be at the mediation. It will usually be at the mediator's office. Maybe it could be at the court reporter's office, or it even could be at one of the attorney's offices. But what will happen is each side will give a brief statement, and then the mediator will break everybody up. Sometimes there's more than two parties involved. In most cases, in the one today, there'll just be two parties involved in the case, plaintiff and defendant. They'll sit in one room together for a few minutes, usually about an hour. Sometimes on a really big case, it could be a couple hours. And each side will tell the other side basically why they're going to win. We're going to win because our client is a nice person and the back surgery was super obvious and she went to the emergency room. And the defendants will talk about their case. Well, we're going to win because this guy had a herniated disc 5 years ago and we have the MRIs and we can prove that it looks exactly the same. So this crash isn't what caused his injuries, blah, blah, blah. So each side will tell the other side why they think they have a winning case and why they're not scared to go to trial. And then you will break up into the caucuses, as we call it. And then the mediator, usually the mediator is somebody who's been in the business for a while. He's taken some mediation classes, and he might even be a certified mediator from the Supreme Court, which doesn't really mean much, but it helps. And what he'll do is he'll go back and forth between the two rooms, and he'll explain and he'll try and get the people to make a deal. And that's it. And if you can't make a deal, the mediator will sign a paper and say, okay, everybody showed up, they did what they were supposed to do, and you show that to the judge, and then basically the judge says, okay, you've complied, maybe this case really should go to trial. It looks like they've been cooperating and they tried to settle the case, but they just couldn't settle it. So that's what's going to happen today. I'm going to do a little bit of behind the scenes, and we'll make another video, but this is a brief explanation of what mediation is and how it works here in Florida. Thanks, guys. Brent Sibley, Sibley Dolman Accident and Injury Attorneys.